A lot of veterans think their gun rights disappeared the day they left the service, signed a VA form, or got help for PTSD. That is not just wrong. In some cases, believing that lie can make you give up rights you still legally have. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from making a mistake that follows you for years. Hit that button now, because gun laws move fast, and confusion is where good people get trapped. Let's start with the first forgotten right, and this one shocks people. Not every bad discharge means a federal gun ban. Most people hear the words bad discharge and assume that's the end of the story. It's not. Federal law uses a very specific term here, dishonorable discharge. That matters a lot. If your paperwork says something else, you should not assume you are automatically banned under that part of federal law. Now, that does not mean every other issue disappears. It means words on military paperwork matter, and you need to read them carefully. Here's what most people get wrong. They hear one rumor at a range, one comment online, or one guy at the VFW saying, "Bro, if your discharge wasn't clean, you can't touch a gun." That is the kind of lazy advice that ruins people. Your record matters, but the exact legal category matters more. Second, a VA disability rating does not automatically take away your gun rights. Let me say that again, because this one gets twisted all the time. A VA disability rating by itself is not a federal firearms ban. Not 30%, not 70%, not 100%. And yes, that includes mental health ratings too. A lot of veterans think the moment they get compensated for PTSD, anxiety, depression, or another condition, they have to sell every firearm they own. That is usually not true. The rating itself is not the disqualifier. The legal question is whether there was a disqualifying event under the law, like a qualifying mental adjudication or involuntary commitment. That is a very different thing. Third, a PTSD diagnosis alone is not a gun ban either. This is the part that really upsets me, because fear keeps people from getting help. Too many veterans believe that if they talk honestly to a doctor, they will lose their rights overnight. That belief can keep people silent when they need support most. Now, listen carefully. A diagnosis is not the same thing as a legal prohibition. Being diagnosed with PTSD does not, by itself, make you a prohibited person. That phrase just means someone the law bars from possessing firearms. Those are not the same thing. Most people think mental health treatment equals automatic disarmament, but the truth is much narrower than that. Here's a hypothetical example to explain this. Let's say a Marine veteran named Chris has a high VA rating for PTSD. He sees a counselor every month. He takes medication. He is still working, raising kids, and living a normal life. In that situation, the diagnosis alone does not automatically strip his rights. But if Chris hears bad information and gives up his firearms out of fear, he may be surrendering rights he still legally has. That is why you need facts, not panic. But here's the crazy part. While some veterans wrongly assume they have no rights, others make the opposite mistake and think service gives them a free pass. It does not. Your service deserves respect, but it does not erase federal or state disqualifiers. So the real game is not emotion, it's precision. What exactly happened in your case? What exactly does your paperwork say? What exactly does your state law add on top of federal law? That is how you stay safe. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when police ask about your gun. Subscribe so you don't miss it, because the people who stay informed make fewer mistakes when the pressure is on. Now let's get into rights number 4, 5, 6, and 7, because this is where things get really important. Fourth, getting mental health help voluntarily is not the same as being legally barred from having a firearm. Have you ever wondered why so many veterans avoid treatment even when they know they need it? A huge reason is fear. They think one hospital visit means their rights are gone. But there is a huge difference between asking for help and being placed into a legal category that triggers a ban. In general, voluntary treatment is not the same as an involuntary commitment. Talking to a therapist is not the same as a court ruling. Taking medication is not the same as being prohibited. That does not mean there are never legal consequences in serious cases. It means you should not assume that getting help automatically destroys your rights. Fifth, you have a due process interest before the government can label you in a way that affects your rights. In plain English, due process means there has to be a real legal process, not gossip, not assumptions, not somebody deciding you seem unstable. This matters for veterans because paperwork can get messy fast. Records get shared. Terms get misunderstood. Old events get described in a sloppy way. And once bad information hits a system, fixing it can take time. But here's the part nobody talks about enough. A constitutional right is not supposed to vanish because of vague language or a bureaucratic mess. If there was no proper legal basis, that matters. Sixth, you have the right to challenge a wrongful background check, denial, or delay. This is a big one. Imagine you go to buy a firearm. You fill out the form, you wait, and then you get denied. even though you believe you are legal. A lot of people stop right there. They get embarrassed. They panic. They think, well, I guess that's it. No, sometimes records are wrong. Sometimes names get mixed up. Sometimes an old case is entered badly. Sometimes a military record confuses a civilian system. If you get denied and you believe it is wrong, you can challenge it. Don't make the mistake of treating a denial as perfect truth. Systems make mistakes because people make mistakes. Seventh, in many states, your military firearms training may count toward concealed carry permit training requirements. Now, this is where it gets interesting, because veterans often pay for training they may not need to repeat. I'm not saying every state does this, they do not. But many states give current or former service members some credit for prior firearms training. Sometimes that means a training exemption. Sometimes it means partial credit. Sometimes it means a simpler permit process. The key point is this: do not assume you have to start from zero just because a gun store clerk told you so. Check your state's actual rules. Now, quick legal note: this is educational information, not legal advice. Always consult an attorney for your specific situation. Let me add one warning here. Here's what most people get wrong. They hear that military training counts in some places, and then they assume it counts everywhere. Bad move. A DD-214 is not a magic pass. Your old qualification record is not a universal permit. State law is where many of these permit rules live, and state law changes fast. So, yes, this can save you time and money, but only if you verify your own state before you carry. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want these updates before they become problems. Click subscribe, because the next mistake you avoid might be the one that saves your rights. Now let's hit rights 8, 9, and 10, because this is where veterans can protect themselves in the real world. Eighth, in many states, veterans may get lower permit fees, faster processing, or special treatment in the application system. Again, not everywhere, but enough places do this that it deserves more attention. Think about how many veterans overpay simply because nobody told them to ask. You walk in, fill out the forms, hand over the money, and never realize there may have been a veteran discount, a training shortcut, or a faster lane for your application. Most people think rights are only about owning the gun, but access matters too. If the law gives you a lawful path that is cheaper or easier, that matters. Ninth, you may have stronger rights than you think when you transport firearms across state lines, especially during travel or a move. This one is huge for veterans because veterans move a lot. Federal law has a safe passage concept that can protect lawful transport in certain situations, usually when the firearm is unloaded, locked away, and you're traveling from one place where you can lawfully possess it to another place where you can lawfully possess it. But here's the warning. This is one of the most misunderstood areas in gun law. People hear one sentence about federal protection and get reckless. Don't do that. The protection has conditions. The gun generally needs to be stored properly. Your ammo should be handled carefully. And the places where you start and end matter. If you are driving through hostile states, bad assumptions can get expensive fast. Imagine you are a veteran moving from one state to another after retirement. Your collection is packed in the trunk. You stop overnight. You cross 3 state lines. You assume your old permit covers you everywhere. That is how people stumble into legal trouble. Now, let me break this down for you. Your right is real, but it is not magic. Safe transport is about doing it the right way, not just hoping your service background will smooth things over. 10th, and this may be the most important one of all, some veterans may have a path to restoring rights after an old disqualifying event, depending on what caused the loss in the first place. This is the part that shocked me when I first started digging into these cases years ago. So many people think once rights are gone, they are gone forever. Sometimes that is true, but not always. In some situations, relief may be possible through an expungement, a set-aside, a pardon, a restoration of civil rights, or even a discharge correction or upgrade, depending on the exact legal issue involved. I want to be careful here, because this area is complicated. Not every case can be fixed. Not every state handles it the same way. And federal law can interact with state law in ways that confuse even smart people. But the forgotten right here is the right to ask the question, the right to investigate, the right to not assume your story ended years ago because one person said so. Here's a hypothetical example to explain this. Let's say a veteran had an old conviction from his early 20s, long before he got his life together. He served, built a career, raised a family, and assumed he could never touch a firearm again. Years later, he learns that his state has a real restoration process for certain cases, or that the original record was entered wrong, or that a rights restoration document was never matched to the background system. If he never checks, he never knows. And that is the tragedy. Not just losing rights, but losing them in your own mind before the law actually says you must. But wait, there's something even more important. Rights only protect you if you stay disciplined. Do not lie on a background check form. Do not assume a veteran's status solves a felony, domestic violence, restraining order, or unlawful drug issue. Do not mix up a diagnosis with a disqualifier, but also do not ignore a real legal bar if one exists. This is where people get hurt. They act on half-truths. They confuse rumors with statutes. They trust social media over real legal review. And let me say one more thing that does not get enough attention. A lot of veteran gun problems start with silence. Silence at the doctor, silence after denial, silence after bad paperwork, silence after a rumor scares you off. The system is hard enough without you quitting before you even check the facts. If something in your case feels off, get your records, read your discharge papers, review your court history, look at your state permit rules. And if needed, sit down with a qualified attorney who knows firearms law, not just a guy who says he knows a little about guns. This information could literally expire after the next law change or policy shift in your state. Subscribe now, because the next video may explain the exact step that helps you avoid a denial, a charge, or mistake that takes years to undo. So here's the big takeaway. Being a veteran does not mean you lost your gun rights, and it does not mean you are automatically protected either. The truth is more specific than that. Your discharge type matters. Your mental health history matters in very specific legal ways. Your state rules matter, and your right to challenge bad information matters more than most people realize. If this helped clear the fog for you, subscribe and share this with one veteran who needs it. You never know who is one bad rumor away from giving up a right they still have, or one bad assumption away from breaking a law they never meant to break. And remember, laws change, facts matter, and this video is general education, not personal legal advice. For your exact situation, talk to a qualified attorney before you act. See 2026 Script Scene Splitter AI GitHub.